the latest episode of Called to the Bar, International Law Over Drinks, a series of informal conversations about current issues in international law, life in academia, and whatever else is on our mind. In these conversations, we are, as always, speaking off the cuff and without the benefit of footnotes, and nothing we say should be taken to have been thoroughly peer-reviewed. I'm Dr. Juliette McIntyre, Senior Lecturer at the School of Law at Adelaide University, and today I am joined by my regular co-host, Professor Douglas Guilfoyle of UNSW Canberra, for an explainer on the unprecedented removal from office of the Prosecutor of the International Criminal Court, Karim Khan. Now, a bit of a content warning, this episode does discuss serious allegations of workplace sexual harassment, sexual misconduct, abuse of power, and retaliation. We're not going to go into any unnecessary detail, but listeners should take care of themselves and skip this episode if that material is likely to be distressing for you. And look, Douglas, before we begin, the traditional first question, what's your drink today?
Well, despite it being a sunny Saturday afternoon, when it might be nice to have a glass of something stronger, particularly given the subject matter, I'm sticking with a San Pellegrino sparkling limonata. And you, Juliette?
Excellent choice. Just behind the aranciata as the best one. But look, I'm actually having, do you guys, dry ginger ale? Who remembers dry ginger ale? Very underrated, right? Okay. I commend it to everyone. Go and buy it and try it again. But look, so this is something which I am vaguely across in a news headline kind of a way, but not really deeply appreciative of all of the subtleties. So the headline that I've read is that the Assembly of States Parties has removed from office the prosecutor of the International Criminal Court, Karim Khan. Could you explain for me, please, Doug, in the simplest terms, how did it do this and on what basis?
Right. So the simplest possible terms might be a bit of a stretch, but I'll do what I can. So under the Rome Statute of the International Criminal Court, which is a treaty, there is a body that's not commonly referred to in a lot of the commentary, the Assembly of State Parties. Now that's the collective body of the International Criminal Court's member states, and it is actually the ICC's management, oversight, and effectively parliamentary organ. It's the thing that passes things like the rules of procedure and evidence. Right. So it met in special session at the UN headquarters in New York on 24 July 2026. It acted under Article 46 of the Rome Statute, which allows the prosecutor to be removed if found to have committed serious misconduct or a serious breach of duty, or to be unable to continue to execute the duties of the office. So the formal ASP decision that was passed at that special session records that the Assembly considered that the OIOS, and we'll come to what that means, investigation report and the underlying evidence, the subsequent report of an ad hoc panel of judicial experts, submissions by Khan himself, and submissions by the complainant identified as V01, and the Bureau's own decision of 8 June 2026. So these were all reports or submissions regarding allegations of sexual harassment or unwanted touching and sexual contact between Khan and the complainant V01. So the Assembly expressly stated that the proceedings were disciplinary, not criminal. It was an institutional decision about continued fitness to hold office. The operative decision found that Khan had committed serious misconduct and a serious breach of duty under Article 46.1 and Rule 24, and then removed him under Article 46.2. Now that was done in a single vote and a single motion, and that has caused some controversy that we can come back to. But in any event, the reported vote was 82 in favour, 13 against, with 15 abstentions. So that's a pretty nearly 2/3. I think it's one vote shy of a 2/3 supermajority in favour of his removal, and removal took immediate effect. Now, the important bottom line I need to stress here is that Article 46 vests the completely uncontested power in the ASP to remove the prosecutor by a simple majority vote where the prosecutor is found to have committed serious misconduct or is unable to continue to exercise their functions.
Hmm. Okay, but I mean, you mentioned this is treated as a disciplinary rather than a criminal matter, because there's not a conviction as far as I'm aware. But maybe there's something we can come back to. But look, I did just want to sort of mention, like, obviously this case concerns complaints of workplace sexual harassment that have been brought by women. Did you maybe want to say a few words about why we've got you, a man, talking about this question on the podcast before we go any
Well,
further?
well, in simple terms, we asked four women, none of whom were available. I also think that senior men in our field do have a responsibility to take these issues seriously. So, in that sense, also our purpose here is principally institutional and legal. We're attempting to do an explainer for outsiders to the court by outsiders to the court. So we're here to explain the Rome Statute framework, the disciplinary process, the procedural objections, and the consequences for the court. Now, we will in the show notes link to the complainant speaking in her own words to CNN. And that said, this is not just the way we're going to address it, really, an abstract question of governance and procedure, right? This case does involve considerations of workplace hierarchy, dependency, immigration status leading to professional vulnerability, and fear of retaliation are all part of the substance here. So part of the complexity here in attempting to navigate this with a degree of sensitivity is the accused party is entitled to procedural fairness, but due process arguments, which some have made a great deal of, should not erase the complainants or reduce the issue to the rights of a senior office holder alone.
Yeah, no, I think those are all really, really good points that you've made. So look, so we know what's happened now. Let's go back and start at the start. I mean, what exactly, we've mentioned sort of sexual harassment, but what exactly was the nature of the complaint that was made against Khan? And you mentioned VO1. Was there one person making these complaints or was there more than one?
Right. So there's only one complainant inside the International Criminal Court, but another woman did come forward with very similar testimony. So I'll go through the facts as I understand them. So the principal complainant, who has been identified publicly by the name Sarah and in the official records as V01, was a lawyer working directly as Khan's assistant at the ICC. It's been reported that she was a person of Malaysian nationality in her 30s. So she alleged a pattern of escalating, non-consensual sexual conduct and abuse of authority over roughly a year after she began working for Khan in February 2023. Her account included accounts of unwanted touching, attempted kissing, and other alleged sexual acts at the ICC, at Khan's home, and at hotels during official travel. She described a situation involving a profound power imbalance, that Khan was not merely her immediate supervisor, but he was the elected prosecutor with influence over her employment, career, and ability to remain in the Netherlands with her husband and son on a work visa. She also alleged that she came under pressure to write a letter to retract or disavow her complaint. Now, CNN reported that the UN investigative record said Khan initially would not confirm whether there had been a sexual relationship, instead denying conduct that was inappropriate, unwelcome, or abusive. His later position through counsel was an unequivocal denial of any sexual relationship, and he also denied pressuring her to retract her complaint. Now, as this unfolded, a second woman, who's been referred to publicly as Patricia, also came forward. She alleged that while working as an unpaid intern for Khan in 2009, before he joined the ICC, but as I recall, when he was working as defence counsel before it, she was subjected to repeated unwanted advances, touching, and pressure to engage in sexual activity. So her allegations were not the basis of the original complaint, but formed part of the broader evidential record considered during the investigation. Khan denied them in their entirety.
Okay. And so, okay, so those are the allegations that were made. So how then did the actual sort of investigation and disciplinary I almost want to use air quotes, but I don't, because I must admit I'm a little bit confused about how much of this has sort of gone through a disciplinary lens, how much of this is criminal, all that sort of stuff. But let's call it a disciplinary process. How did that all kind of unfold at the ICC?
Yeah, so I think it does bear stressing that at no stage has this involved criminal charges, although obviously non-consensual touching of any nature, but particularly of a sexual nature, would constitute an assault. So
Yeah.
this is one of those things where a lot of people will say, well, even if this is a disciplinary procedure, these are very serious allegations and should be subjected to a stringent standard of proof, possibly even a criminal standard of proof. I disagree with that approach, but this was entirely a process about essentially workplace conduct. So I would characterize it as a disciplinary workplace investigation.
Gotcha.
So anyway, the allegations first became public in 2024, and as far as I understand, it was not necessarily Sarah herself who first made them public. The process then ran for almost 2 years and became highly contested. Now, just at the outset, it's obvious that that process went on for much too long in terms of fairness, both to the complainant and the accused. And as it unfolded, the process was marred by changes of process and applicable rules that looked, frankly, improvised and ad hoc. So initially, the court's ordinary internal independent oversight mechanism, essentially a kind of Office of Internal Affairs, was involved. And it became involved through a third-party referral. So someone other than the complainant and Khan said, I believe this has happened and it needs to be looked at. And indeed, the prosecutor also referred the matter to the IOM once it had been brought forward. But the IOM closed its case when the complainant refused to participate. They rather unsatisfactorily said, well, we can't do anything. So the Assembly of State Parties, this is where things get a little complicated. There's a standing committee of the Assembly of State Parties called the Bureau that kind of runs day-to-day management and oversight of the court. So it took a decision to refer this question, this investigation, to the UN Office of Internal Oversight Services, the OIOS I referred to before. So the Office of Internal Oversight Services assembled a substantial evidentiary record. Again, public reporting suggests this record ran to literally thousands of pages. Public reporting also said its report found a factual basis for the allegations, but did not itself make any final legal or factual determination of misconduct. Essentially, it just assembled this enormous dossier of evidence and testimony. So then the Bureau, following revised rules for disciplinary investigations passed in December 2025, appointed an ad hoc panel of 3 judicial experts to review the material. Now, that ad hoc panel of 3 judges concluded that there was insufficient evidence to establish misconduct beyond a reasonable doubt. Now, why that was considered the appropriate standard is beyond me.
Yeah, that's what I was going to ask. Like, that's the criminal standard that we wouldn't. That's why I was sort of emphasizing this criminal versus disciplinary question, because you would need to establish that standard for a criminal conviction,
Yep.
but ordinarily for any other kind of civil or employment type situation, that wouldn't be the standard that's required.
I do not know why that was the standard that was applied. I don't know their terms of reference and I don't know how they interpreted them, but certainly in an Australian employment law context, for example, it would remain a determination on the balance of probabilities, but subject to what we in this country call, and there are similar principles in other common law countries, the Briginshaw principle, which is that if the allegations are unusually serious, you need particularly strong evidence to be satisfied of the nature of the allegation, which is a complex idea to employ, but technically, as a matter of law, the standard of proof doesn't change. You just need to have a better quality of evidence to reach that balance of probability level of satisfaction.
Yeah.
So
The
in
scales
any
are just
event,
set to a slightly different, the scales are just set to a slightly different
yeah,
setting, as it were. Yeah, yeah, yeah.
yeah.
Sorry, I interrupted. Karen.
No. But anyway, so that finding that nothing could be proved beyond reasonable doubt or established beyond reasonable doubt was portrayed by Khan as a positive finding that he was exonerated. And he made social media and other statements to that effect. The New York Times, however, reported relatively soon after that the panel had in fact concluded there was evidence pointing to non-consensual sexual contact. There was evidence, it just didn't meet the beyond reasonable doubt threshold. So the Bureau of the Assembly of State Parties then conducts its own assessment of this now sort of three-stage investigatory process, and it was entitled to do that under the revised disciplinary procedure, and it disagreed with the panel and suspended Khan in June 2026, and then referred the matter to the full Assembly with a recommendation from the Bureau that the appropriate course was removal. Now, it said that at the special session, the Assembly as a whole considered, or its members were able to consider the investigation, the expert advice, the party submissions, and it's important to note that both parties did get to make written submissions, and the Bureau decision, and then in a single resolution it made its own finding of serious misconduct and serious breach of duty.
Okay, so, all right. So bear with me while I wrap my head around this. So I've heard, I mean, that seems like a fairly long and detailed sort of a process, but I've seen a lot of commentary online that is critical of the sort of procedural concerns related to this removal, saying that there was a lack of due process and so on and so forth. So what were those critical sort of procedural concerns that people had? Do you think they're well founded or?
So there's probably about 5 high-level concerns I could address, but I would say that yes, this process has proved quite divisive, I'd say, of opinion in the international criminal law community, with some people taking very strong positions either for or against Khan's removal. So the first concern that could be raised is that the process changed course while underway. So critics object to moving the investigation from the IOM to the UN OIOS, amending the governing procedural rules during the course of the case, and then creating an ad hoc panel of legal experts, but then later departing from its advice. The second concern is that that panel of judicial experts found that misconduct had not been proven beyond reasonable doubt, and some critics argue that diplomats on the Bureau substituted their political assessment for the legal judgment of independent experts. So, why retain experts if you're not going to follow their advice? Mm-hmm. The obvious point here is that that panel was advisory, and Article 46 vested the ultimate decision in the Assembly, and also that advisory panel did not hear witnesses directly, which limited its ability to assess credibility, which I would think to some extent is going to be the principal issue in a case like this. As we've already said, beyond that, I think beyond reasonable doubt was the wrong standard of proof to apply. So then the third concern becomes that an alleged shift in the factual basis of accusations against Khan. So some critics say that the process began with allegations of non-consensual conduct, but the Bureau ultimately relied on the existence of a sexual relationship rendered improper, regardless of consent or not, because of the power imbalance involved. So conversely, supporters of removal would say, well, this wasn't a criminal indictment with fixed charges. The disciplinary body was entitled to characterise the conduct disclosed by the record and assess the prosecutor's fitness to continue in office. And I would tend to agree with that view. A fourth concern that was raised has been whether Khan should have had the right to be heard before the full Assembly. That said, he'd made extensive submissions to investigators, the panel and the Bureau, but critics argued Article 46(4) of the statute entitled him to address the plenary body deciding his fate. Now, I don't agree with that conclusion as a matter of law, but as a matter of procedure, it might have been preferable. The fifth concern, and this is very technical, is whether there should have been 2 votes. First, a vote perhaps on a two-thirds standard, to find serious misconduct, and then an absolute majority vote second on the question of removal, rather than one combined decision. Now, I won't go into the argument that a finding of serious misconduct should require a two-thirds vote, beyond saying, as far as I can work out, it requires drawing inferences from other provisions in the rules of the court, but those rules can't displace the express powers given in the court statute itself. They're subordinate instruments, right? They're at best of interpretive value. So
yeah, Procedure Goblin agrees with you on that one.
right, great. So, and then the body that has the authority to determine what Article 46 means and how it should be applied is the Assembly of State Parties, right? And that's the practice of the states who own the treaty in evidencing their understanding of how the treaty should be interpreted and applied. And they thought they could do all of this in one resolution, and it does contain two different operative paragraphs, one finding serious misconduct and breach of duty, and a second deciding on removal.
Yeah, and you mentioned that it was like one vote sub two-thirds anyway, so it seems like fairly immaterial difference potentially at the end of the day. The one that bothers me, sorry, have I cut you off? I have questions. The one that bothers me the most, speaking as someone who's a bit obsessed with procedure, is the first one that you mentioned, the way that the process changed course while underway, or that the procedural rules were changed during during the whole investigation and eventual removal. That's the thing that sort of is such a red flag for me. And do you think, do you think this is because the court, or the body of the ICC as a whole and the ASP included, was sort of caught a bit by surprise by these developments and just didn't have a process that was organized? Is this kind of like sexual harassment, workplace bullying? Is this a new phenomenon that they just hadn't thought to deal with yet, and as a result they were kind of making it up as they went along? And maybe that's worth criticizing, but if at the end of the day the result is good on the substance, maybe that's okay. I don't know. What do we think?
Yeah. So it's clear that the court or the Assembly of State Parties had to improvise because they didn't have a sufficiently detailed procedure for dealing with allegations of sexual harassment or workplace bullying. And they should absolutely not have been caught by surprise by this. And this is, in my view, a pretty grave management failure, because earlier independent reviews had already identified bullying, harassment, a culture of fear, discrimination, and perceived impunity among senior officials at the court as problems the ICC faced. So we had an independent expert review of the court in 2020. And at that time, 130 staff spoke anonymously to an external workplace culture panel about their experiences of racism, sexism, bullying, and sexual harassment. And that, that IER body produced a more than 300-page report with more than 300 recommendations. So the idea that the court was not on notice that this was a serious issue that might require proper processes to deal with is fanciful. Also, Khan himself came into office promising a safer workplace and stating that the court could not preach justice and gender equality in the courtroom without practicing them internally. So, to my mind, that history makes present developments especially damaging. This wasn't an unforeseeable shock. It rose against the background of a known institutional culture problem that the ASP and the court leadership had had years to address.
Yeah, so I mean, I'm trying to unpack this in my own mind because, like if you say they've had years to think about how you manage the court as an institution, as a workplace, then they really shouldn't have been having to improvise these procedures from the get-go. I think it's personally, I think it's valid to criticize the procedure as you've described it to me, sort of switching from body to body with different standards being applied, and no sort of real clarity about where it was going to go from day one to day two. I think that's a worthwhile criticism of the procedure. And I think it's also valid to say that the court maybe ought to have had something in place for this type of workplace management situation, if they've had so long to do it. But I mean, they obviously did improvise. They obviously were caught on the hop due to lack of preparation or lack of paying attention or whatever that is. Yeah, they improvised. So
Yeah, I'd agree with
I don't
you.
know what
And
else
that
to
kind
say.
of ad hoc rulemaking during a live case creates risks
Yeah.
to fairness, consistency, and legitimacy for the complainant as much for the accused.
Yes.
But also, it's created a lot of, frankly, to my mind, distraction about the fairness of the process rather than the real issue here is the seriousness of the conduct at the heart of it. And I guess when it's a question of fact finding, those two things can't be disentangled. But I think it is really unfortunate that this is one example of a very serious issue that's been facing the court for a long time. And to some extent, the chance to get this right has been just undermined by the process involved, and as I say, that creates problems both for the complainant and the accused.
Indeed. And look, I'm trying to think how to phrase this, but if if this same process had happened back in 2020, maybe it wouldn't be quite such a big deal because the other thing that I've seen online a lot of is that this process of the ASP removing the prosecutor is politicized. It's a politicization of the court, right? That these diplomats have stepped in, that they've overruled a panel of legal experts and removed a senior court official. Obviously, that's a highly contentious sort of proposition, but given all of the kind of commentary that we see about the court at the moment, yeah, I think it's maybe a concern some people have that this is not just about the very serious allegations, but that there's other stuff going on as well. Do you think that this reveals a certain politicization that's going on in the background as well?
Well, I mean, that concern is not entirely unfair. Could certainly say that prosecutorial independence could be weakened or gravely undermined if states can remove a prosecutor because they dislike the course of their investigations or they dislike that certain arrest warrants have been sought. But that was not the case here. This case was not a summary dismissal based purely on political grounds. It followed an internal complaint, an external UN investigation, an expert review, written submissions, suspension, and a special session to consider the evidence. But also, there is an unavoidably political element here for two reasons. The first is Article 46 expressly entrusts removal of the prosecutor to the state parties, and states are political actors. That's just a fact. Also, the prosecutor himself is an elected official, right? He is not a career international civil servant. And who elected him? States. Who removed him? States, by a parliamentary process. Now, there's nothing actually particularly exceptional in that, and I can hear people howling at me already, but judicial officials can be removed by parliamentary impeachment in most democracies. That said, if you look at the ICC statute, the statutory safeguards are noticeably thinner for the ICC prosecutor than for judges. So judges, there has to be a prior recommendation by other judges that this judge should be removed. So there's a further procedural hurdle before the Assembly of State Parties can consider such a case. That's actually stronger protection of judicial independence, again, than you would find in most democracies, right? So my thought here, and again, it's an unpopular one, is that ultimately many ICC supporters have a rather romantic and impractical view of what judicial and prosecutorial independence actually entails. And at the end of the day, unpopular as it is to say this, the International Criminal Court is not a magical body existing on a different plane of law that's directly empowered by natural law or by Klaus Kress's jus punidendi of the international community, lovely as it would be if those things could be true. It's an intergovernmental organisation that derives its power from sovereign member states. And it's accountable to them, and it's funded by them. And more than that, frankly, it has underperformed since its inception. But that's That's a separate question on which I've written and commented quite a lot.
Yeah. I mean, I'm not familiar with, say, how you remove like how you would fire a prosecutor in a domestic sense at all. But yeah, like, judges absolutely need to be protected. Their independence needs, because they're the ones who are making the final determinations. But the prosecutor it has an important role to play, but it's a role in a broader organization. Like, there's not sort of, I don't know.
Yeah,
Anyway, we don't get into that.
I think the International Criminal Court's a very particular context in that
Yeah.
the prosecutor really is the linchpin of the court. And a lot was, in the design of the court, kind of swept under the rug of prosecutorial independence. And every time anyone said, oh, but what about this? What about that? The answer was, no, 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 the prosecutor will be independent and of high moral character. So none of those concerns should ever arise. And the difficulty there is that, the prosecutor has a very difficult job. They have to initiate cases. They have to decide where the evidence leads. They have to decide on the distribution of finite resources across, an enormous geographic area of jurisdiction and spectrum of criminality. It is a very difficult job, but it was not really everything about how cases get start and move forward is driven by the prosecutor. I mean, judges have to confirm arrest warrants and obviously make findings of fact, but there's, other than this power of removal, there is no oversight for the prosecutor in a sort of managerial sense, other than when he seeks to bring particular cases or particular arrest warrants before the court. But again, who makes the decision about which cases and which arrest warrants move before the court? The prosecutor. This isn't a civil law system where the judges can direct the conduct of investigations, though from time to time they have attempted to micromanage the prosecutor, and that's been one of the tensions in the court. So it is perhaps a more important role than the domestic analogy would suggest. But I come back to the point. At the end of the day, this is an elected official, not a career civil servant. They're elected by a parliamentary body. They're accountable to a parliamentary body. And if that parliamentary body concludes that they have committed serious misconduct, that body that elected them can also remove them.
It makes sense. I mean, I wonder is some of, or much of, I don't know, the controversy related to this partly because we've seen at the same time, whether related in fact or just coincidentally, this US attack against the court. We got threats of US sanctions. We've seen a number of individual member states withdraw. And then just recently, Rubio going that they're going to dismantle the ICC, brick by brick. Pretty sort of outward threats. Like, is it? I don't know whether those two things are, whether the removal of the prosecutor is in any way, shape, or form related to those threats. But they're certainly happening at the same time. What's going on there? Do you think?
Well, this is one of those extremely unfortunate things where the accusation is sometimes made that the allegations against Khan were either politically motivated to begin with or were pursued in a particular manner because of political concerns. I think it's really important to keep the removal of Khan and the more hostile geopolitical environment in which the court is operating analytically separate. So two things can be true at the same time. The court had to investigate serious internal workplace allegations, and external actors have taken advantage of the court's perceived disarray. Those two things can be true at the same time. It is also, I think, true to say there is no concrete evidence that anyone can point to suggest that this case came about because of that external geopolitical pressure. But as you say, the US, same old, right? The US position once again portrays ICC jurisdiction over the nationals of non-party states, and the usual countries of concern to the US are the US and Israel, as an attack on state sovereignty. Now, that's obviously nonsense for reasons we've discussed before at length in this podcast. But bluntly, or to oversimplify it, the court generally acts on the basis of territorial jurisdiction delegated to it by a state party. And states ordinarily have jurisdiction over crimes committed on their territory, including by foreigners. So there is nothing contrary to international law here at all. The US stance is also obviously selective because Washington supported ICC action against Russian nationals in Ukraine and has previously supported the court's involvement in Darfur and Libya. So, it's international criminal justice for thee and not for me.
Yeah.
But the practical threat is serious. Sanctions can affect officials, banking, travel, service providers, and potentially, one would think, the willingness of candidates to stand for prosecutor. And the reach of US financial jurisdiction, or the overreach of US financial jurisdiction, we discussed recently in our episode on dollar hegemony with Dina Savala. And yes, as you say, several states have now initiated withdrawal procedures, including Venezuela, Burkina Faso, Mali, Niger, and Chad. These take effect after 1 year but are not retrospective. So the court will still have jurisdiction over events in those states prior to the withdrawal taking effect. Some of those states in leaving, they haven't referred specifically to these proceedings, but they've alleged geographical bias and disproportionate focus on the global south, the usual criticisms of the ICC. That said, reduced cooperation by Chad could impact ongoing investigations in Darfur.
It's difficult, isn't it? Because you're right. Like the court has now, look, the criticism about the global south is well known and so on. But we were maybe getting to a point where the court was being a little bit more active in different regions, Ukraine and so on. And then they've now lost their prosecutor. And they're under this pressure from the US, the threats of sanctions and so on. What's going to happen next? Is anyone going to want to step up into this role under those potential sorts of threats? What happens next for the court at this point?
Well, the two deputy prosecutors have been running the office of the prosecutor since Khan was suspended. So the court's work continues, and the court has said that its mandate and its existing cases continue. The Assembly has to design and run a new prosecutorial election. So again, questions they haven't had to address before include, would this person just be filling in the rest of Khan's term, or do they start a completely new term as prosecutor? So that is itself going to be a test for the court's governance structure. And it's also important to say that, in terms of the allegation that somehow this is all kind of politically confected, well, the court's active warrants and investigations don't disappear with Khan's removal. In particular, the warrants authorised by the judges, admittedly, warrants Khan put up, but once they've been authorised by judges, they remain judicial acts of the court. In terms of will anyone want to stand, look, never underestimate the ambition of international lawyers. I'm sure, candidates will be able to be found.
Well, thank you so much, because honestly, I was just kind of flummoxed by the whole thing, and you've done a really good job of just breaking it all down for me and explaining it. But look, that's all been rather grim. So let's end on our traditional, slightly lighter note. For those that don't have the benefit of the Zoom call, could you describe your rather fabulous outfit for us today, please?
So I'm recording today from my garden office in Canberra, which also doubles as my sewing studio. So I've been running errands today in a combo of chocolate corduroy trousers that I made myself, a similarly coloured brown suede waistcoat, and a chore coat made from kind of a bold sort of autumnal check or tartan in brown, green and blue. And anyone who follows me on Instagram will probably be able to find a photo of me down at the Belconnen markets in that gear today.
A chore coat in a bold autumnal pattern is a sentence that I think only Douglas could get away with. Look, thank you so much for guiding us through a difficult and unprecedented episode in the life of the court. I really appreciate it.
Oh, thank you for hosting, Juliette.
Anytime. And thank you to the listeners for joining us on Call to the Bar International Law Over Drinks. We will see you again soon. Bye-bye.
Bye.